Good afternoon, everyone. We've all entered the webinar as mute attendees, but Zoom webinar features a Q&A tab where you can ask any questions during the program. We'll collect them all and answer either live during the webinar or afterward by email. And also you can click and drag the boundaries between the windows to adjust the size of the slides or the presenters. And now, after a brief introduction, we'll proceed with today's webinar, as always, co-sponsored by the University of Florida Levin College of Law Institute for Dispute Resolution. And now our presenters, April Walker and John Jopling.
Hi, Kathy. Thank you so much for opening today. Hi, John. Good to see you again.
Good morning, April.
John and I decided that we would invite you to visit our webpage profiles to learn more about us in terms of our litigation backgrounds and our mediation experience. But for today, I'll just say that in mediation, I have acted in the role as outside counsel for plaintiff, defendants, counter plaintiffs, counter defendants. So prior to 2018, I've mediated cases on both sides of the table. And of course, since joining Upchurch Watson mid-2018, I have mediated cases exclusively as the neutral. And so I will be bringing that perspective today. John?
Thanks, April. My background is one of civil trial litigation for close to 40 years in Gainesville, with a lot of that focus on medical malpractice. I've been mediating since 2018 and exclusively doing so for the last 4 years. So enjoyed working with folks at the Upchurch firm, and especially my collegial relationship with my co-presenter today, April.
Absolutely. It's a pleasure. It's been fun working on this with you. So we'll jump in. Next slide. So, of course, today we're here to talk about emotional intelligence in mediation. The term emotional intelligence, or EI, is sometimes used interchangeably with the term EQ. EQ is actually the term for the measurement of a person's emotional intelligence. And of course, EQ is very different from IQ, which measures a person's overall mental ability using standardized testing. John and I agreed that I would say, the ankle to knee deep discussion of EI to set the parameters for the discussion today. And then he will take the lead as we talk about the various stages of mediation. Next slide. So EI, or emotional intelligence, is the ability to first recognize, understand, and manage your own emotions. And second, recognize, understand, and influence the emotions of others. It involves, of course, being aware of emotions in yourself and others. But here's the critical next piece: using this awareness to guide your thinking and behavior. Next slide. We included this slide because, frankly, we wanted to depict how many emotions at any given time any of us may be experiencing. So the first slide, I think, is probably 25 emotions on what is referred to as the psychology emotional wheel. And then as many as 80 emotions or emotional responses at any given time. And so emotions, while we don't often think of them, they're often always in play. Next slide. This is a cute slide. This is from a movie I didn't see. John, you did?
I did, with grandchildren in tow, I believe. So,
is it called Inside Out?
I think that's what I recall. I recall the characters more than anything else.
Okay, so we included this slide because initially we thought we don't want participants to be prepared for a deep dive in EQ assessments or deep diving into emotions, because mediation is not therapy. And then John just kind of, I would say, gave me a check on that in terms of his perspective.
I did, and I really like this slide that illustrates some of this. I think one of our whole central points of our message today is that while mediation obviously can't serve the purpose of when folks have emotional issues about the litigation, mediators and lawyers aren't psychotherapists, right? But at the same time, one of our points today is that we need to recognize there are real emotions involved in the process. And people bring those emotions with them in very real ways, and they impact the way they think about mediation, the way they think about possible compromise, and that as mediators, we need to respect, to be aware of, to respect those emotions, and to do what we can to guide them in a positive direction toward the goals that mediation actually can accomplish, which of course is resolution of the conflict.
Excellent. I don't have another word to say behind that. Agreed. Next slide. Okay, so here we want to address essential preparation that takes place before we say every mediation. I think in my mediations, I see this as happening, I'd say 98% of the time. So before mediation, we believe every attorney is preparing themselves, then preparing their client, then preparing their mediator. And in their meeting with their client, they're agreeing on an end goal for that mediation, as well as hopefully some strategy discussions on how they might work towards that agreed end goal. So that's preparation before mediation. Next. Once you get to the mediation, however, I and John agree. You don't want to mediate a case on autopilot. Rather, you want to rely and utilize certain skills during every mediation. And these skills include, first, emotional self-awareness. Second, self-regulation, also referred to as self-management. Social awareness, and then relationship management. These, in fact, are the 4 domains of the EI framework. Next slide. And so we want to give proper attribution to Daniel Goleman. I've heard him referred to as the father of emotional intelligence. I mean, it's 2026 now. You can read from a lot of different sources about emotional intelligence, but we want to give credit where credit is due to Mr. Goleman. And so those first skills, those 4 skills that I referenced in the previous slide, are in fact the 4 key areas of emotional intelligence. And then in this slide, you'll see underneath the big circles or smaller circles that represent the competencies or skills associated with each area. We today intend to talk about, I think, 6 or 7 of the competencies, and those are the 6 or 7 we believe most applicable to mediations. Next. And so first, the first area, self-awareness. Emotional self-awareness is the heart of emotional intelligence. It's the ability to understand your emotions, how they affect you, and how they affect your performance. Next. The second area is self-management or self-regulation. And we're going to talk about 3 skills on this one, although I think John will probably throw in a 4th towards the end. The ability to keep disruptive emotions and impulses in check so that you can remain effective under stress, when you're juggling multiple demands, even under hostile conditions. That's emotional self-control. The next skill is the ability to stay focused on goals, but easily adjust the means of achieving them. I like to think of this as being nimble because, of course, you're in the moment receiving information and you're juggling the demands of interacting with multiple people. And this is, in fact, adaptability, being focused and yet nimble as you move towards your goal. And then third in this one, the third skill, positive outlook, the ability to see the positive in people, situations, and events. I think this is very important because, frankly, negative energy impacts everyone around you. So the ability and the willingness to remain positive despite setbacks and despite what's happening in real time. Next slide. The third area, social awareness, a word we are all familiar with when it comes to mediations, I think, and EI, and that's empathy. The ability to sense the feelings of others and their perspective, how they see things, listening to understand their perspective, taking an active interest in their concerns. I actually saw another really good definition I wanted to make mention of, the ability to emotionally understand what other people feel. see things from their point of view and imagine yourself in their place. I think that piece of imagining yourself in their shoes is something we often think about when it comes to empathy. So I wanted to add that there. Next slide. And finally, the fourth of the four areas we're going to be talking about today is relationship management. And indeed, mediation is all about relationship management, and not just for the mediator, for the lawyers that are there as advocates. So we're going to talk about three skills: influence, the ability to have a positive impact on others, to persuade, to gain their support. Second, conflict management, the ability to help others through emotional or tense situations. This also involves acknowledging the views of all sides while redirecting energy towards a shared ideal. And then finally, teamwork, which is more than just the ability to work together or work with others towards a shared goal. It also involves participating actively, sharing responsibility in the process, as well as sharing rewards. I like that breakdown because teamwork is about more than just showing up and working together. Okay, that's the last of the four areas, and I think we're ready now to shift into our discussion about application to the stages. John, next slide.
Well, April, thank you for that overview of the subject of emotional intelligence. I think a lot of the concepts are ones that we as mediators and lawyers have sort of they sound familiar to us, but we often haven't seen them in this kind of, if you will, academic framework that I think is helpful to our awareness of them. So let's turn then and talk about how we see these competencies, I like that term, of emotional intelligence used actually in the mediation process and in each stage of the mediation process. First of all, let's talk about emotional intelligence in the preparation phase, and we'll start with that from counsel's perspective, because as you have seen, we are going to look at this from both the perspective of those of you who are participating in mediation as counsel as well as mediators. The one that I start with, that I think, as April has said, the whole process maybe needs to start with, is this concept of self-awareness. And I think of that in terms of asking myself, as counsel, how does the other side see me as a negotiator? And how can I use that perception to my client's advantage? The question may come up, if I am seen as a particularly pugnacious or aggressive participant in mediation or as a negotiator, I need to sort of self-reflect on whether or not that could be modulated and might best be modulated to reach my client's real goals in this particular mediation. The idea of emotional self-control obviously is a key element as well. And particularly in the preparation process, as a group, without overgeneralizing here, I have to say that maybe trial lawyers are not generally thought of as the most introspective or self-reflective group that's around. But the idea of spending a bit of time in preparation thinking about what are those things in this litigation that are triggers for me, or emotional hotspots for me, that can throw me off my game in terms of how I want to approach mediation. Maybe it's a history of conflict in this case with this particular opposing counsel. Maybe it's the insurance company that I've dealt with before and had unhappy relationships. By being aware of those sore points for me as counsel, I can be better prepared to stay focused on my client's real goals at mediation. Here, as a sort of best practice pointer here, we hear over and over again from counsel that appear before us as mediators, and it's been our own experience back when we were mediating as lawyers, that a pre-mediation phone call with opposing counsel, while maybe not appropriate to every case, probably not appropriate to every case, in many, many cases can be very helpful in saving time at mediation, in getting rid of some of those sore spots, perhaps, or mitigating them at least, and having an idea about the best strategy going forward at mediation with opposing counsel. And then finally, again, this idea of empathy must include a thorough understanding of what your client's real needs are out of this mediation. And frankly, that includes an awareness of not only their needs in terms of a dollar amount. We understand that's the ultimate outcome of mediation, but also understanding your client's the emotional impact the litigation has upon them, and to the extent your client is particularly focused on that, and knowing that mediation and litigation is not always a remedy for that. How do we redirect them toward the goals that mediation can accomplish?
Agreed. I like your point on the sore spots and the triggers. I often think it's best in preparation to prepare for those. So
Right.
oftentimes it's not a surprise when you hear the argument you think is misguided based on the law. You've heard it before, you've had a conversation with counsel, rather than come to the mediation expecting it and not preparing for it emotionally. I think develop a plan for it. The plan may be to address it proactively. The plan may be to have law ready for discussion to send to the mediator. It may even be identifying particular evidence that you can share screen and just immediately address it, rather than just showing up and going through the entire emotional response when you could have been prepared for it. I would add self-management from counsel's perspective, self-management for you and your client. I think in preparation with your client, you want to proactively address with the client their need to be emotionally aware and keep disruptive emotional responses in check. And then I also think for this phone call where you're preparing for this mediation with your client, you've got a conflict management function, and that is to unearth disagreements or gaps in agreement with you and your own client. As it relates to the end goal, as it relates to the range of numbers that you're hoping to mediate in. If you're not on the same page, then that translates, I think, into preparation call and or including something about that in your mediation summary. So conflict management can and should begin with counsel before the mediation. And last but not least, it's obviously an influence function when you're getting your client's buy-in for a strategy for the mediation. So those are all things I think that are happening in most of those prep calls. John?
Exactly. I'm glad you mentioned that, April. One of the things we frequently hear in that pre-mediation phone call with opposing counsel, it's an opportunity to say to your opponent, I'm aware of this issue that you think is strong to your case, but my client is exquisitely sensitive to that issue. A common one that we see is where there's an issue perhaps of comparative negligence, and in a case of real loss, the party to whom that is directed may be so thrown off by that emotionally that it really distracts them from being able to concentrate on negotiation. So having that kind of conversation and discussing those issues, it may not mean that you completely ignore that issue, but at least you are aware of the effect it'll have on the other side, and you can make an informed decision about whether or not that's something you can give up talking about, for example, in opening statement.
And leave it to the mediator to talk about.
Right.
Good point. Next slide.
Here we talk about emotional intelligence from the mediator's perspective. In terms of conflict management, it's difficult to manage conflict if you don't know the key points of the conflict. In just about every case we mediate, we find over and over again that the real difference in perspective of the two sides often comes down to one or two key factual differences about how the case would be decided if it went to a trial, for example. We find as mediators the best way to be aware of this, of course, is a careful review of submitted materials, which, by the way, we understand how busy court dockets are and the busy life of trial lawyers. Neither April nor I are so far removed from those days that we've forgotten what the time demands were upon counsel going to mediation. But really and truly, I can tell you that those submittals that you give, first of all, mediators do read them. We read them closely. And by the way, as a practice pointer for mediators, I strongly suggest you read those submittals not just for what they say, but for what they don't say, because we can often get a real flavor for what the real issues are by noting the points that aren't made in those submittals. Another practice that I often use in terms of conflict management and getting a sense of the temperature of the litigation is a quick docket review. Just about every circuit in the state now has a fairly easy to use. There's some difference in the user friendliness of those different clerk's offices, but we can go to a docket and look and see what the history of the litigation has been from the court's perspective. And that will often give us a flavor. If we see 15 motions to compel or motions for sanctions, we know something about the temperature of the case. We can see how long it's been going. So that's often helpful in terms of getting an idea of how to manage the conflict that's coming. The last one that I want to touch on here is this idea, and to me it touches on two different aspects, both empathy and social awareness. I think it's very important for mediators to recognize the either real or sometimes perceived differences that the two parties may have as they go into mediation in terms of the power dynamic between them. We often see that one party, usually but not always, the plaintiff has a sense of disempowerment or of imbalance that they're up against the wall. The other side is holding all the cards, so to speak. And by being aware of that, it lets us start to use our influence competency and our conflict management competency both. And I suppose, and April, you may have thoughts on this. I'm sure you do about the teamwork. But getting folks, by emphasizing to a party that feels like it's at disadvantage in the power structure here, emphasizing to them their rights of self-determination, that their right of autonomy in this process, and letting them know that they control the outcome just as much as the other side does. As well as emphasizing the mediator's neutrality, I think is helpful to mitigating those feelings of lack of control by the parties involved.
I like that. I think that's right. And I also have said to you that in working with you on this project, I've decided there's something I can do a little differently here. And that is, I think as mediators, we often find out from counsel when a dispute is particularly acrimonious or they expect there to be a lot of negative energy. And yet there are times that we don't really proactively ask. So instead of waiting for the conference to feel out emotions and or waiting for counsel to tell you, I think you can become more proactive in just asking, how's your client feeling about this? Or what's your client's temperature? And if you're reaching out to counsel early enough, you ask that question before their client prep meeting and they can remember to ask. Mm-hmm. Sometimes a client may be resigned. Sometimes a client may really just not, there are other emotions than just the angry, frustrated, impatient emotion. So you can include that as part of your preparation as a mediator so you can be prepared and not just get there and find out. Because oftentimes, and we're going to talk about this when you move on to caucus meetings, sometimes we're talking to the lawyers more than the parties themselves. So we want to make sure we check in with them early and at the beginning.
Right. Very good.
Next slide.
I think we covered that one. Yes. Let's talk about emotional intelligence in our opening sessions. And first, from counsel's perspective, the big factor here, I think, is self-awareness and self-control. And in preparing for this, I thought about, and I bet all of you listening have probably had this experience in your own life. Whether you were having a discussion with your spouse, or the instance that comes to my mind is at a partnership meeting that I had once. I think we've all had the experience of being involved in dialogue or discussion that had an element of conflict to it, where we were absolutely clear in our own mind how very deliberately soft-spoken, reasonable, and easygoing we were being, only to discover that the person on the other side of that dialogue, whether it was spouse or law partner, saw our and heard us entirely differently. Differently than we intended, differently than we thought we were communicating ourselves. So an awareness of how others are perceiving us from the standpoint of our word choice, our tone of voice, our volume of voice, even body language, an awareness of that. And then, of course, having the self-control to say, you know what, it doesn't really matter in terms of what I get done today and reaching the goals I have today. It doesn't matter whether I perceive myself as being soft-spoken and reasonable about this. What matters is how it's perceived on the other side. And so that's where the self-control piece of it comes in, I think. In other words, maintaining a genuine sense of civility is extremely important from counsel's perspective, particularly in those opening sessions. The other piece to this, I think, that's so important. Again, we keep going back and forth with it. We use this over and over again. The importance of empathy. The phrase that comes to my mind here is one that's attributed, I think, to Saint Benedict. That talks about listening with the ear of your heart. Now, we won't get off on a side discussion here on what for some of you may be Ash Wednesday. You may be observed as Ash Wednesday. So we won't delve too deeply into the spiritual significance of that phrase, but I want to talk about the very practical applications of that in mediation. That is listening with the ear of your heart. What that means to me is not listening with the idea of what's my lawyerly response going to be to that? How can I counter that remark? It means listening, and April mentioned this at the beginning, listening to hear what the emotion is behind it, what the emotional appeal is of the other side. In other words, listening, as mediators often tell folks, listen as you think an objective juror would hear it. Because we all know jurors don't just hear testimony at trial with the left side of their brain, they react the emotional side of their brain as well. And if you want to understand what the best alternative to negotiated agreement at mediation is, that is what a jury may do with this case, you really have to hear the other side as a neutral observer would, which again, I suggest involves that listening with your heart as well as your head. Relationship management and influence, from counsel's perspective, I think it involves having an informative tone to your opening statement as opposed to a persuasive one. It's very easy for all of us as trial lawyers to lapse into our advocacy role. It comes very naturally to us. Coming across more as teacher than advocate in opening statement is often much better skill of relationship management in the mediation context because, as we all know, even the best advocates among us can seldom say, oh, yes, we changed the other side's mind about their own case at mediation. However, coming across as here is genuinely what I want you to know so that you can make an informed decision, and I'm going to listen to you that way. So, because I want to understand your position, so my client can make an informed decision about the alternative to litigation. So, those are the key aspects, I think, of the emotional competencies that counsel need to have in that opening session. April, what have I missed here?
Some of what you said is also conflict management, right? Because it's
Sure.
identifying areas of a disagreement, because obviously you disagree, you're on opposite sides of the case. But if you can take the step of finding something about the other side's point of view that you can acknowledge, that goes a long way. And I've made mention before, John, there was a Voice of the Mediation Client video premiered by the Florida ADR section recently, and also the OCBA here in Orange County, Florida, that compiled client feedback on various stages of the mediation. And I'll tell you, some clients shared having to essentially close their ears during opening sessions so they don't get frustrated and change the end goal they came in with. Because of something they hear. So I think if you can go the extra step of finding something about the other side's point of view and add it in, that goes a long way. We heard that in that particular video. And then also, I think verbalize something that conveys a desire to work together as a team. I know we usually hear, we're here in good faith, try to get this resolved. But I think really making a deliberate effort to think about how can I convey something that's a building block for a bridge and absolutely avoid the dynamite in the opening session. So for the mediator's perspective, John.
Sure. One of the aspects that I try to be aware of as a mediator, and I think we all do, is an awareness of the sense that many litigants bring to mediation of mediation, maybe like the whole litigation process, is something that happens to me or is done to me, something that's going to be imposed upon me. So as a mediator, I like to be aware of that. And again, we've talked about ways of awareness, the pre-mediation phone call with counsel to sort of understand where folks are coming from in that respect. But I like to emphasize pretty heavily to the parties again there that this is something that it's not we're going to reach an agreement today if you agree to emphasizing their autonomy, their right to decide this. I like to tell folks, despite what our egos sometimes tell us as mediators, we really know that mediators don't settle cases, right? We can facilitate, we can help with communication, we can grease the skids, if you will, but it's parties that settle cases. And I think it's important that parties who feel like they're not in control to be given that control back. And as a mediator, I think I can help do that. And along the same lines, just the general creation of a sense that they're in a safe space. They're not under the gun here. We, of course, emphasize this particularly in the confidentiality aspect of mediation. But even beyond letting people know that nothing you say here is going to be used against you. It can't be. It's absolutely here. It's more just a general sense of creating a feeling of informality. I think that as a mediator, that comes with things as simple as having a little bit of chit chat at the beginning. From you heard Rachel and I talking about weather, but just getting a little sense of who the folks are there and finding some common ground. I often find that folks, may know something about Gainesville, or maybe they're Florida. I hope I don't turn off half the audience here. Maybe they're Florida Gator fans, and we can talk about the latest basketball game. But simply putting people at ease, I think, is an important part of creating a sense, an environment in which resolution can more easily occur.
I think, in addition to what you've said, influence and adaptability. So, as the mediator, I think you want to gain support from all participants for a process that is non-adversarial, one that encourages candid conversations in privacy. Of course, explaining the confidentiality requirement, and then also gaining support for a process where your mediator is going to be coming and going to receive information and share information. I think when you do it that way, you're beginning to set the stage for them preparing for your role of coming in, coming out, talking to you, asking for permission to share, and or you've already agreed that they can share unless you tell them they can't. And so that's an influence function. Also, adaptability. Oftentimes we go to mediation, we start with a joint meeting, we go to caucus, never to see each other again. I think it's important for people to know that process can be adapted. I think in certain instances, there are times that we go to caucus, and more often than not, the parties will remain separate. Sometimes, depending on the case, everybody may reconvene briefly. Sometimes there's been a misunderstanding of something in the factual background. Usually this is in instances where there's an ongoing relationship, and irrespective of how the case or dispute ends, these parties are going to be in relationship, like sometimes bank and borrower cases, sometimes business disputes among people that are going to still be in business. Sometimes you're going to bring folks back together for a brief segment to talk through something specific, and then you can go back to caucus. So I think letting people know that this is an adaptable procedure allows them to be flexible as they move into those sessions. Next slide.
Very good. Okay, well, now we're at the place where we spend, 95% of our time in most mediations, the caucus sessions, of course. From counsel's perspective, again, while we're in a different venue now from opening statement, of course, but the idea of self-awareness and self-control, including control of our tone, our volume of exchanges with the mediator, how those affect our client's perspective. Now, look, we get it as mediators. we don't disregard the fact that there's a performative element to this sometimes, right? We get that. But at the same time, it's important to realize that as counsel, the way you listen to, the way you respond to the mediator's questions affects your client's perceptions and affects your client's openness to resolution. So it's important to be aware of that. That also obviously falls into the area of conflict management, and there taking after folks have had a chance to vent, after folks have had that chance in opening statement to be heard about their perspective, and they will continue. We see in mediation, folks continue to want to express that, and as mediators, we need to be patient with that and invite that, in fact, but still bringing people back from the areas of conflict to what do we hear about today, folks? We acknowledge, we are aware of, we respect and acknowledge your differences and the emotional impact this has on you. Let's come back to what we can get done today, which is seeing if we can find common ground. Again, we'll talk about this at several points, but there's both ends of that. I think it starts with an acknowledgement of the differences, an acknowledgement of the emotions that people are feeling, but then being able to move from that back toward a focus on how do we get things done today. And it includes, I think, from a counsel's perspective, a real focused awareness of how your client is responding to this. Now, that includes body language as mediators. I like to watch and observe both counsel, but the parties as well. How are they hearing what's going on? How are they perceiving it? And as April has suggested, the idea of, as mediators, checking in with the client. We'll talk about that from the mediator's perspective. But from counsel's perspective, again, being aware of the effect of your own approach and demeanor and maintaining that positive outlook on how do we get there and what's our goal today. Rachel, April, where did I get this Rachel from?
I don't know.
I'm working with someone by that name elsewhere, but I really do know you, April. So
if we had time, I'd ask you who Rachel is.
Yeah, right.
Don't answer.
You don't answer, right.
Okay, on caucuses for counsel, I would say emotional awareness, empathy, and teamwork are my thoughts. So first, I think coming out of the opening session, John, ask your client how they felt about what they heard. I mean, just because usually as a mediator, try to give them a little time walking out of the opening session to debrief. Ask them how they felt, locate them, locate yourself, and then just make sure that the client after the opening session is in the same place you were in your prep meeting. Make sure that the strategy and the end goal are still in play, okay? Because again, you want to make sure you're still moving in the same direction that you had agreed to. And then on empathy, you mentioned active listening. I would say this, we usually think of active listening directly, as in I'm listening to you and I'm nodding, John. But now you're not talking with the other room. You're talking to me. You're talking to John. You're talking to your mediator. So active listening to the mediator as the mediator comes and goes. And yes, I agree. Let the mediator share for your client's benefit. Usually caucuses are longer at the beginning of a mediation. More information is being shared. Sometimes there are lengthy caucuses throughout a mediation, depending on the case. But I feel personally, John, you can agree or disagree. I think it really cuts short your client's opportunity to hear the neutral lawyer in the meeting if you're dismissive of what the mediator shares. So, I mean, I would say patience and allow the mediator to come and share, because as the lawyer, you already know your answer, but there's a process I think you want your client to go through that involves hearing the other side, evaluating that, and thinking about how that may affect either the evaluation, the case value at the mediation, what your goal was when you came in the meeting, and or maybe it's something they need to be in the back of their mind as you move forward if the case doesn't settle. So I think that for counsel, mediator's perspective, John?
Yeah. Again, I think the idea of self-awareness. Am I maintaining and communicating clearly to counsel and particularly parties my position of strict neutrality? And where I think this is particularly as important is obviously when we're dealing with litigants who aren't familiar with the mediation process. This is oftentimes, we started, those of us who deal with mediations day in and day out sometimes forget how the process can be bewildering and seem a different perception altogether from the people that are new to it. I like to point out to those kinds of litigants that the reason that I'm asking probing questions is not because I'm advocating for those positions or telling them that the other side is right about them, because that's how it comes across sometimes. If you're only hearing the mediator in your room, you don't know that the same hard questions are being asked in the other room. So I like to explain to litigants why I'm asking those questions, not as an advocate for the other side, but to make sure that both sides have fully examined all the issues and are making informed choices about what they want to do.
Yeah, you can always say it's the devil's advocate hat, but yeah, you
Sure.
definitely want to make sure they know you're doing the same in both rooms or all rooms for multi-parties. And then, yeah, I think you want to, again, continue and keep support for a process that's allowing you to do that. And of course, you've got to be sensitive to the responses you're getting in the room. You may have to scale back. And then you also have to have some savvy as the mediator and experience in how to do that in a way that does not put the client and lawyer in a bad position. Okay, next slide. We're running a little bit behind, John, but let's.
Sure. So we'll move a little quicker today on this one. Emotional intelligence in negotiations, again, from counsel's perspective. I think the important aspect here is adaptability, being open to things that you learn in mediation. That's one of the benefits of mediation, of course, is that sometimes we do acquire additional information that may change our negotiation strategy, or at the very least helps us to adapt as we go forward from mediation. Again, this idea of achievement orientation, meaning a focus not on here's where my assessment was when we came to mediation, but how does the offer in front of me compare with what mediators call BATNA, or best alternative to negotiated settlement? How does this resolution that's being offered today compare with my most educated guess about what's going to happen at trial? That sounds obvious, but it's often it's easy to lose that in the back and forth of mediation. Again, being aware of how your client is responding. We see all the time where a client may, because they're not familiar with the process, early on when they're not happy with what the other side is, they may be dismissive of the process. As counsel, keeping our clients engaged in the process and willing to work toward this. Again, the idea of teamwork, maintaining a common effort. We're here to solve a problem together, and keeping your client focused on that. As part of that, I like to talk about what I call a non-reactive negotiation style, where you are simply making logical negotiation moves toward what you have determined is your reasonable bottom line, if you will, as opposed to negotiating in response to what the other side is doing. Because after all, you can't control what the other side is doing. So rather than taking the approach that we as mediators hear all the time, well, I'm not going to do this because they haven't moved as much as I would like. And of course, we're hearing that in the other room as well. Simply a negotiation toward what a resolution that makes sense to you and your client. And finally, from the counsel's perspective in the negotiation, the idea of regularly, as April says, checking in with your client, making sure that your client feels heard and respected and a part of the process. And by the way, I didn't mention this earlier, but as part of that, we'll speak to this, I guess, in the mediator part of this. But in multi-party litigation, I also think it's important to focus on the risk benefit for your client and not worry about what other defendants may be doing in the next room, because again, that's not something you can control.
Well, and we may have no ability to share with you if we're not authorized to share with you as a co-defendant. That means then, as co-counsel, co-defense counsel, you would have touched base to reach some agreement on that. And I would also say here from counsel's perspective, it's a lot. It can be a lot depending on the dynamics of your room, managing that relationship. If you need to step away, I think it's easier when you're on Zoom, right? Because if your client's in a separate location and you can pause, you can mute, you can turn off audio, you can take a break, you can call the mediator. When you're together, if you need to kind of take a minute, we can incorporate 5 minutes into our time out of your room if you need it. Sure. So next slide. Last one on negotiations.
Sure. And this one we'll keep brief, but from the mediator's perspective, again, keeping folks engaged in a positive keeping folks thinking about trend lines, movement, that we are moving in a certain process toward a goal. It may not be at the speed that you were hoping for or liking for, but staying engaged. And I didn't mention this earlier, but one important part of this from the mediator's perspective, I think, is, and I often say to the parties at the very beginning, I want you to know that while much of my conversation may be with counsel, I hear you, I see you, and I know you're here, and I invite input from you as a mediator. Whatever you want to tell me, whether it's a criticism of the process or a comment or a question, regularly letting the participants, the litigants, know that they're the focus of this, and this is not just an abstract legal discussion between two lawyers, one who happens to be a mediator and their counsel. I think that's important to keep people feeling engaged in the process.
Agreed. I like to check in as I'm coming and going with the party, even if I'm speaking with the lawyer more often. And then just as a basic point, I don't walk in and just talk to the lawyer. I'm talking to the room. I'm talking to the client as well. I've got a few thoughts on this one, and I think it's adaptability of the process. So when you're in the negotiation stage, I think it's important for the mediator to ask her or himself or discern what is needed to continue constructive discussion. So in the beginning, there can be movement, there can be progress. And then if things look like it may be slowing down and or nearing a breakdown, I think it's going to be on the mediator, obviously, to determine what's needed. Is it a break? If you haven't gone to bracketing or anchoring yet, maybe doing that, maybe an attorney mediator conference away from the clients. And in some instances, maybe a reconvening depending on those very limited circumstances. I'll tell you though, you never convene unless lawyers know they've got a client who can do what they did in opening in terms of tone, building blocks for a bridge and not dynamite. And I think that's probably it for me on this slide.
Good.
Okay, so now we're going to talk about EI and other scenarios at mediation. I think we probably have 3 that we're going to address. First of all, the hallway discussion. I like to call this the attorney-mediator conversation. We're on Zoom. Go ahead, John.
Sure. This is probably one of the most common sort of alternative scenarios that we see at mediation. And it can, in our experience, it can often be very helpful. From the counsel's perspective, it's important in terms of relationship management to be sensitive to the impact of a hallway discussion on your client's sense of self-determination. Obviously, the client needs to feel like this is not nobody's talking behind my back. It needs to be explained to them. This is why face-to-face communication may be helpful here and may break down some barriers. So make sure that we would suggest that your client understands why a hallway discussion may be helpful. And of course, that means coming back from a hallway discussion and letting them know what that was about and how it went. In terms of influence, the competency of influence, we see over and over again in these hallway discussions that there's oftentimes more of a willingness of counsel to be a little more direct about real bottom lines than in a face-to-face conversation. Or sometimes we have an exchange that lets one counsel know, look, here's the emotional hurdle that other counsel, am dealing with in my room. How can we move past that? And sometimes a real collaborative or teamwork approach while still being the zealous advocates we're required to be, can be very helpful in bridging that. Particularly, we find obviously near the end of the discussion. Sometimes at the beginning to sort of set some parameters as well, but particularly at the end.
Yeah, I would say on relationship management, definitely involve your mediator. So when you include the neutral lawyer at the meeting and then the neutral lawyer goes back in the room with you to share what happened, I think that that also builds upon the client's trust and what happened outside of their hearing. Also, you want to make sure you protect the relationship of the mediator. Usually these discussions are not going to happen without the mediator being a part of it. So typically when this happens in my mediations, I'm the one who's bringing the issue up, or I'm the one that's raising it. Even if counsel says, I think I want to step out, I'm the one to facilitate the conversation with the other room to see if that's okay. Because I want to make sure the parties at this mediation understand I'm still, shepherding the process. Okay.
Right.
Next.
At the end of mediation, hopefully, and we all know in the great majority of these, resolution is reached. It's important to remember the values of validation and affirmation. That is, you know, it's easy to think we've all been through the tension of the mediation process. It's easy to think, boy, once we've gotten that final word that things are agreed to, that we're done. It's very important to understand that the emotional impact of that is still going forward, and to let folks know by saying simply things, good work, good teamwork. We know you've all worked hard here. We know you've all made compromises here, so that one party doesn't feel like, as sometimes happens, oh boy, I've really given away the farm here or sacrificed too much. Letting them know that this has been a truly collaborative process that both sides have worked toward. That kind of validation and affirmation, I think, goes a long way toward sealing the process and having everyone have a positive sense about what they've done.
Yeah, I think here, this is why really from the beginning through the end of the mediation, you want to be conscientious of emotions. And I think if you've been coming and going in the room as the mediator and you've been keeping, your finger on the pulse, you certainly will know if a resolution has been reached, but someone feels they probably are way further from their original agreed end goal. I think you just want to be sensitive to that. And I think we have to be careful not to think we're done once agreement is reached during the final stages of interacting with the parties to get a written agreement reduced to writing. Because if someone has really had to sober up to some weaknesses in their case, there may be a huge divide in terms of what they came there to receive and what they're leaving with. And you want to be sensitive to that, counsel and the mediator. Next slide.
I think this is a really important piece. As mediators, we don't like to think too much about the times when we don't get a mediation done. But it's occurred to me, if we're genuine when we tell people that they have agency, they have the right of self-determination and autonomy, then we have to recognize that, just because we didn't reach resolution doesn't mean any of the parties failed here. As long as they participated in good faith and made a genuine effort at it. So I think it's important that, number one, we encourage folks to remain adaptable and to learn from what they may have learned at mediation, to rethink the problem somewhat, to taking into consideration, we have a better idea now of what the other side's not only view of the facts of the case are, but their needs and wants in terms of resolution, keeping folks viewing the day as that sort of learning opportunity, not a failure. I often tell folks at the beginning, look, we're here. My job as a mediator is to make sure to do everything I can to make sure people make informed choices about how to move forward with this matter. We hope that will result in resolution, but if it doesn't, what can we take from it, including this idea of achievement orientation, remaining focused on future possible resolution based upon the progress that we've made at mediation.
Yeah, this is the time where I really hope all of my, authorized sharing of information has been reduced to notes. When you haven't reached an agreement, but you want to receive the value of the neutral that you've paid to mediate this case for you. Hopefully, if and I'll just tell you, my tact is to share as much as I'm permitted to share, because if it doesn't settle, then you've received some value. I mean, I want this to be a fruitful meeting, and obviously the best ending is when it's settled and there's a final agreement, and all you have to do are the steps it takes to finalize the agreement. But otherwise, I love what you've pointed out here, particularly willingness to rethink as you then retool for the next stage of the litigation. But absolutely, I think you're spot on here when it comes to when resolution is not reached. And please, people, take notes during mediation, because you're going to want those notes.
And by the way, as a personal practice, I maintain my own notes, detailed notes of mediations that don't resolve for a prolonged period of time, so that when people call me back, as they sometimes do, I can still assist by going back to where we were. So.
Well, next slide. We've covered a lot. So this was the original framework. We've covered even an extra competency, because you just addressed achievement orientation. Next slide. We have just a few minutes before we conclude, and Kathy provides you with the closing instructions to get your CLE credit. Of course, for those of you attending as mediators, it's self-reporting. But we had a question or two that we were going to try to address. I think we may be able to get through one question. So, John, and by the way, the slide is simply Dan Goldman's quote, that EI is a different way of being smart. And I hope that what we've shared with you today brings to the fore, first, a lot of things that you're already doing, but maybe helps you think more intentionally about this at every stage. So now, the question we wanted to address, Daniel, did I say Daniel? I got you back, John.
Is that right, Rachel? Rachel, I'm going to spend some time thinking where that comes from.
I'm so glad that happened. Okay, so the first question, I think we're going to only have time for one now with that flub. What are some strategies for dealing with a party that's focused on vengeance? When we saw that, we thought, wow, okay, I'd love to know more in terms about the dispute, but you want to take a crack first? We've got probably 2 minutes before Kathy.
Sure. And, this question in our mind was sort of paired with another, I think, that asked in general, how do we deal with emotional conflict at mediation?
To avoid impasse, yes.
Exactly. My thought real quickly here is that it's easy as a mediator to, and some of us who are sort of results oriented, we want to say, well, get over it. We're not, you're not getting vengeance here today. All you're going to get is money. That's the short left brain answer to it. I think that's a mistake. I think, first of all, when this is an issue in a case, whether it's overtly expressed, or explicitly expressed, or whether it's something that, again, using our empathy and our emotional awareness, we pick up on in caucuses or in openings. I think then it's important as mediators that we both acknowledge that emotional reality, that we respect it, and in some extent, and I do this, even validated as saying, I genuinely understand why you feel that way, but then helping to redirect parties back toward, again, what can be accomplished. Because one way or another, we can tell folks, if you're really angry at the other side and you think something terrible ought to happen to them, well, that's not something we can get to in this process or in the litigation process. Here's what we can do. And also emphasizing to them that by focusing on resolution, and if we can get there, that although we're not therapists, going back to that earlier slide, oftentimes resolution of the underlying conflict helps to resolve or at least soften the underlying emotional impact they have. That's the only way I know to deal with these kinds of issues.
And Kathy, if I can give 2 sentences before you close this out, ma'am. Do I have time?
Go ahead.
Thank you so much. So, John, my thoughts on this was, when I hear punishment or retribution, I think, is this a punitive damages case?
Right.
And so I think if I want to steer a party, if I want to kind of get out of the emotional and enable us to have a conversation that may result towards a resolution, I know that non-economic and economic damages are not awarding money for retribution or punishment. So if it's not a punitive damages case, I think that's a way to talk about it with the client. And I think counsel with the client needs to address this early in the prep stage, if necessary. Talk to the mediator. And if you're not able to get traction, you might even want to request a preparation call with the client and the mediator to begin to turn the table away from that emotional towards the legal remedies that are going to be on the table when you get to the conference. I think that's it. We don't have any more time. Kathy?
All right, here we go. If you are a Florida attorney, please jot down the Florida Bar course number so that you can post your CLE credit online. It is 2600107, N as in Nancy. Again, that is 2600107N. Please watch your email inbox for news about our future programs. Registration is now open for our March 11th webinar, Top 10 Tips for Mediating Aviation Cases with Rodney Max and Brad Hassel. And on this slide, you're going to see some contact information to reach out to today's presenters and for technical assistance. And I think you got us off to a really good start on our CLE webinars this year. April and John, thanks so much.
Thank you, Kathy, for all that you do. John, I enjoyed it.
It was a pleasure, April. Thank you.
And we'll field any questions we receive by email. Thank you all for coming. We enjoyed it.